The Honorable Chief Justice and Associate Justices of the Supreme Court of North Carolina. Oh yes, oh yes, oh yes, the Supreme Court of North Carolina is now sitting for the dispatch of business. God save the state and this honorable court.
Good morning. Our first case this morning is Carolina Mulching Co. L.L.C. versus Raleigh-Wilmington Investors 2 L.L.C. Shalimar Construction, Inc. We'll hear from the appellant.
May it please the court. My name is Bradley Cox, and I represent the defendant appellant in this matter, Shalimar Construction, Inc. I would like to reserve 5 minutes for rebuttal. The main issue here in this appeal is that there was insufficient evidence to support the trial court's findings that Carolina Mulching satisfied all the terms of their contract with Shalimar and mulched all the trees up to 8 inches in diameter. And the key issue of the key issue is how the Carolina Mulching actually defined diameter. And as we get into the testimony, it's clear that they had an erroneous definition of that common term. Just some basic introductory facts. The plaintiff, Carolina Mulching, provided a quote to Shalimar for mulching trees and brush up to 6 to 8 inches in diameter in the 8.5 acres of land for development on Main Street in Nevada, North Carolina. My client Shalimar agreed, incorporated that quote into the terms of the contract. Both parties executed it. Carolina Mulching worked about 12 days out on that site and then left. Shalimar then hired a D&L Logging who cut the remaining trees on the 8.5 acres. The exhibit that was produced showed that he cut 13 loads of wood and 325 tons. He also testified that the 1.5 loads of that was over, only 1.5 loads was over 8 inches, and therefore the rest was should have been cut by Carolina Mulching under their contract. Shalimar refused.
Counsel, I know that this is not like a pivotal point in the case, but it is correct that the Carolina Mulching would have complied with the contract had they only cut up to 6 inches. Isn't that right?
No, Your Honor. The quote in the contract was they would mulch trees and brush up to 6 to 8 inches in diameter.
Well, but the point is up to 6 to 8 inches means you can comply with that if you do 6 inches, because up to 6 inches would be up to 6 inches. That's not up to 8 inches.
I think that the understanding of the contract was that it would be up to the maximum of that. Otherwise, I'm not sure why you would have 8 inches in that contract at all. You could just say up to 6 inches. I guess the question there is, well, why do you need the 6 in there if it's 6 to 8? I think that's how they drafted the quote, and I think that the meetings of the mind between the parties were that it was 6 to 8 inches. In the testimony and in the trial, there really was no dispute as to the 8 inches. I think the dispute was, what is the 8 inches? Is the 8 inches, how is that measured? Is that a diameter, which is supposed to be, or is that a circumference? There wasn't really any controversy over the number, just the way it was measured, we'll say that. And getting into that, the testimony in the trial, first from Shane Stevenson, who was the owner of the plaintiff, testified, and I'll just quote him, and this is from his own attorney. Question: what is the significance of 6 to 8 inches in diameter? Answer: well, to me, like judging a tree, and you do it every day, all you look at is trees for 8 hours a day, so you know what the machine's capable of. So to me, 8 inches is like this, you know, if you put a tape measure around it, that would be 8 inches, give or take. Question: so we're talking 8 inches around it? Answer: yeah. Later, he then indicated on a photograph trees that had remained. testified that those were greater than 8 inches and were therefore not included in the scope of work. But again, he described how he estimated the quote-unquote diameter.
Let me ask you, let me jump in for just a second. Good morning, Mr. Cox.
Yes.
We're here on the basis of the dissenting opinion from the Court of Appeals. And the dissenter said that there was a finding of fact that Carolina Mulching satisfied the terms of the contract, even though it was erroneously called a conclusion of law. And there appears to be a different position by the other side that the trial court didn't resolve the issue of fact about whether the correct trees had been cut. Do you agree with the dissenting opinion that statement in the trial court's order that it satisfied the terms of the contract was a finding of fact?
Well, I think the issue is that the majority, well, in my initial brief to the Court of Appeals, I had basically two arguments. One, that there was no finding of fact to support any conclusion of law. And the second was that if there were findings of fact or actual competent evidence that did not support the conclusion of law, that they followed all of the terms of the contract. The majority then ran with that and said, well, there was not a finding of fact to support any conclusion of law, and that's why they wanted to remand back to the trial court to make further determinations. The dissents, I don't know if it's correct or not, whether or not that's a finding of fact or conclusion of law, but I think the central point and the thread of the dissent was there is no conflicting evidence here. All the evidence that was shown supports the conclusion, and in that there was not a completion of the terms of the contract.
Well, I guess what I'm trying to get clear about is that, as I understand the difference between the majority and the dissenting opinion here, is the majority thought that the trial court needed to make the additional findings of fact to support the conclusion, and the dissenter didn't think additional findings were necessary, and that we could just direct the conclusion to be entered by the trial court. And you're here on the basis of the dissenting opinion. Do you think we should just direct the trial court to enter the conclusion without making the finding?
Yes, I think that you would direct the trial court to make the conclusion and make that judgment and finding in favor of my client Shalimar.
And is that because you, like you just explained, you don't think there's any conflict in that testimony about the definition of diameter?
That's correct. There's no conflicting testimony or evidence in the record regarding what the Carolina Mulching definition of diameter was, which essentially is circumference.
Okay, thank you.
Sure. And continuing on with that, Mr. Hall, working for the plaintiff, also testified, quote, "I would not have left the trees if they were under 8 inches in diameter." Question, and again, we're talking about how Mr. Stevenson described it as take a tape measure around it and measure that tree and it's 8 inches, 8 or smaller, right? Answer, say that again. Question, sure. Mr. Stevenson said if you take a tape measure around the tree and measure it, and if it's 8 inches or less, that's correct. And I think, again, the majority has said, well, we'll remand because there's conflicting or contradictory evidence. So you may think, well, why shouldn't we just remand it and let the trial court, figure this out and get it right? Well, again, while the majority talked about conflicting evidence and contradictory nature of the testimony, they really didn't identify any testimony that did conflict. They just made that as a conclusion in their opinion. And I did not cite this case in the brief, but the Cumberland Homes, Inc. v. Carolina Lakes Property Owners Association, 158 North Carolina Appellate 518, says that where a trial court fails to make required findings or conclusions, the appellate court may order a new trial or allow additional evidence to be heard by the trial court, or leave it to the trial court to determine whether further findings should be on the basis of the existing record or on the record as supplemented. They go on to say remand is unnecessary, however, when the facts of the case are undisputed and those facts lead to only one inference. And we would contend that's what the dissent found, and that's what we are asking for here today. To go back to the trial court, you're allowing additional evidence. You're letting the plaintiff, another chance to present additional testimony, additional evidence after he's being educated. So we would say that because they haven't met their burden of proof at the trial court level in the first trial, they shouldn't, for judicial economy, fairness, they shouldn't get another shot at that.
Can I ask you about that?
Yes.
Hi.
Yes.
So it is possible to remand and ask the trial court to make findings, and I think what the as I read the Court of Appeals, they're referring to the finding where the trial court said, here's the contentions of the parties, but then didn't tell us which testimony or evidence they were crediting to, and the trial court, did come to a conclusion. Isn't it entirely possible to remand for the trial court based on the record as it exists, not reopening the record for any more evidence, but based on the record as it exists, to tell us which of the contentions they found supported by the testimony?
I think that's, I don't know that that is possible, frankly, based on the record. If you is looking at the record, I don't know what the trial court can pull out of the testimony in the record to say, oh yeah, what they really meant when they said diameter, they really meant diameter. So certainly they could make findings of fact to that and make a finding of fact that diameter meant diameter, and then say that based that on the conclusion of law. I think then we're right back at the appeals court, and I'm arguing there is no competent evidence on the record to support that finding of fact, which then supports that conclusion of law. There's some testimony, and I'll just go into it a little bit, that was cited in the brief by Mr. Dugan about a cut string that was presented at trial and some sort of cardboard cutout. None of these items were entered as illustrative or demonstrative evidence. I don't know, nobody knows where they are now. There's really nothing for the court to consider there as evidence in the record, or even for the trial court to consider if you remanded on that. The testimony in the hearing is that from my client was Mr. Edwards, that the string was about 7 inches, and put it in a circle was what Stevenson and Hall had testified to. Again, that's the circumference. He then talked about something was 8 inches. It's unclear as to what he's referring to. Mr. Hall then was recalled, asked about a cutout, and said it was 5.5 inches. There's really no identification on what that was, if it was the same thing that Mr. Edwards talked about or not. And 5.5 inches really just doesn't fit either with diameter or circumference. When you're talking about an 8-inch diameter, tree or circle, you're going to have a 25-inch circumference. And if it's an 8-inch circumference, you're only going to have about a 2.5-inch diameter. That's all of my presentation, unless any of the panel has any additional questions.
Thank you, counsel. We'll hear from the appellee.
Thank you, and good morning. May it please the court. Chief Justice Newby and Associate Justices of the Supreme Court, my name is Tim Dugan, and I represent the plaintiff appellee, Carolina Mulching Company. This case is ultimately about the breach of a contract. However, we are here before the Supreme Court on the dissent of Justice Dillon from the Court of Appeals. And rightly, as recognized by some of the justices earlier today, the actual issues identified in Justice Dillon's dissent were basically, one, whether or not there was a finding that the plaintiff, Carolina Mulching, mulched all the trees under 8 inches in diameter. Two, whether or not there was evidence to support that finding. And three, ultimately, should the Court of Appeals have reversed the decision of the trial court and instead entered judgment in favor of the defendant. When we first looked to whether or not the finding of fact that the plaintiff mulched all the trees under 8 inches in diameter, that specific language isn't found anywhere in the trial court's order. Justice Dillon found in conclusion of law number 3 that the plaintiff services included mulching trees 6 to 8 inches in diameter, and that the plaintiff satisfied those terms of the contract. Justice Hudson, when you were asking whether or not that could be a finding of fact or a conclusion of law, I believe North Carolina's law states that a pronouncement by the trial court which does not require the employment of legal principles will be treated as a finding of fact, regardless of how it is denominated in the court's order. In my initial appeal to the Court of Appeals, I think I was indeed arguing that there was additional findings of fact laid out in the conclusion of law section there that could have supported the order as well. However, the actual...
Let me ask you something about that since you're on it. Was there a specific finding about which trees were to be cut?
Judge, no, I don't believe there was any specific findings on what the trees to be cut or what they weren't to be cut. The findings from the trial court were that there was an agreement to cut all trees up to 6 to 8 inches in diameter. I believe the testimony to address Justice Newby's concern was that some of the trees are thicker or, I guess a more dense. So this type of tree, the machine might only accept up to a 6-inch diameter versus a pine tree or something softer might accept up to an 8-inch diameter. So the actual findings from the trial court, I think there's no contention that they didn't properly cite what the contracted work was to be done, which is to basically clear the overgrown land and to mulch all the trees under 6 to 8 inches in diameter. The majority opinion from the Court of Appeals, I believe, rightly recognized the fact that through the findings of fact in the trial court's order, Judge Gore from the Brunswick County Court acknowledged that there was trees left standing after the plaintiff performed the work, but doesn't resolve whether or not those trees were indeed greater than 6 to 8 inches or lower than 6 to 8 inches. So that is certainly one of the grounds on why the case should have been remanded back for those additional findings for the trial court to actually say, we found that there was trees left standing, but we didn't find that it was credible that they were more than 8 inches or under 8 inches.
Well, what do you say about the defendant's contention that there's no conflict in the evidence about the mistaken definition of the trees to be cut, and that we should just order that the conclusion be made?
I believe that there is an actual conflict in the evidence, Judge. The testimony from Shane Stevenson earlier in the court, and then the testimony from Cameron Hall, admittedly is an erroneous statement about the definition of diameter. However, I think the most important contention is that following this entire trial, we did these visual representations. Specifically at page 99 in the transcript, we can see that when David Edwards was subjected to the cross-examination from myself, we started by asking him to cut a piece of string. And admittedly, as Mr. Cox pointed out, I did not move these into evidence, but it was certainly evidence for the court to consider when they were watching these visual demonstrations. And of course, Cameron Hall was sitting right next to me also watching these demonstrations. So when Mr. Edwards cut an 8-inch piece of string, we can see a diameter of what would have been about 8 inches. And then when we folded that back in on itself, we could have seen a circle that would have had a circumference of about 8 inches. Additionally, we asked Mr. Edwards to cut out this cardboard cutout. Now, it ended up in my file because we did not move it into evidence. I still have it, but obviously it's not in the record for the court to consider today. But what I'd say is, if we look at the actual language of what Cameron Hall testified to, we had Mr. Edwards cut out a circle from a piece of cardboard that he would have estimated to be 8 inches in diameter. He then when Cameron Hall was called back up on rebuttal, he identified that circle as having a diameter of approximately 5.5 inches and said that that was consistent with the size of the tree that he would have cut. This later testimony, or after this visual demonstration, is what is important to the court, because now it shows that regardless of how he identified the method of measuring a tree earlier in the trial, that he was indeed measuring a tree based on actual diameter as opposed to the circumference. If he was only cutting 2.5-inch diameter trees, he would have said that this cardboard cutout that he identified as 5.5 inches would have been outside the scope. So it's clear from his testimony, in light of those visual representations, that he understood what the actual scope of the work was.
If he was cutting trees that were up to 5.5 inches in diameter, was he satisfying the contract?
The Justice, I think that's, it's just a lot. The demonstration there was just illustrative of the fact that he understood the distinction between diameter and circumference. He testified that he was measuring trees based on diameter, not on circumference. And this was, I believe my exact question was, we've spent a lot of time trying to figure out the distinction between diameter and circumference. Were you measuring trees on circumference? And this is now where you can say, no, I was measuring trees based on diameter. So he does say that he was initially that he had cut all of the trees under 8 inches in diameter. And then this testimony, in light of the visual representation, shows that he did actually understand that distinction between diameter and circumference.
But since he testified both describing circumference and that he understood diameter, you contend that the trial court should resolve that?
Yes, Judge. I didn't cite this in my brief either. If we look back to Gunn v. Bluebird Taxi, it's 212 NC 540. This is a case from 1937 in which the court has ultimately said when a person makes a misstatement during their testimony, it is ultimately up to the trial court. That goes to the weight and credibility of the evidence. So it's certainly for the trial court to determine which testimony to believe. Is it the earlier or the later? It's no different than when you impeach any other witness on the stand. Do we believe the unimpeached testimony or the impeachment testimony to figure out what is credible? So ultimately, that would have been a decision for the trial court.
So I want to be sure, because this is really the essence of the case, in my opinion. What precisely is the evidence that you say makes an issue of fact about whether your client understood and cut trees 6 to 8 inches in diameter as opposed to circumference, when it appears that the testimony of your client was that you take a tape measure around a tree as opposed to across it?
Yes, sir. So again, I believe that the strongest testimony in favor of that would have been Cameron Hall's rebuttal testimony at pages 135 and 136 in the transcript. Pull up the exact words here. When we had Mr. Edwards perform those visual representations with a piece of string to show the diameter and then the cardboard cutout to show an example of a diameter.
Okay, right. But help me understand how we're supposed to have any idea what's being talked about when it's not into evidence.
Well, I think that certainly the transcript is illustrative, even just based on the questioning. Again, I understand that we didn't move the actual exhibits into evidence. Question, I believe there's a cutout up there for you. Is that roughly the size of the trees you were grabbing? And Mr. Hall identifies that as 5.5 inches. So I guess it, in theory, could require the court to read into it that it's that same cardboard cutout.
But how are we supposed to know what a cardboard cutout? I mean, if we don't have it as evidence, how are we supposed, or even the trial court, if it goes back, is the trial court supposed to use its memory of something that was not introduced into evidence?
Admittedly, Judge, at this point, it would be difficult for them to do that because it's not physically in their possession for them to review it. Again, I think it would have to be focusing on the transcript there, about the actual visual representations, about what was being described by Mr. Edwards at the time when he was cutting out these, either the piece of string or the cardboard cutout for the court to kind of understand what was actually before the court.
And there's no dispute that use of the term diameter in this circumstance is the industry standard, correct?
I believe that would be correct.
Was there any indication in any of the agreement as to where diameter was to be measured? So is it to be measured at the ground? Is it to be measured at 3 foot in height? Where was the, again, there may be nothing in the contract or in the evidence. I'm just asking.
Right, there was nothing specifically in the contract. I believe there was some testimony from at least Mr. Cox's witness there that the industry standard would be at breast height. But I don't remember that being specifically outlined in the contract. I think it was certainly the 6 to 8 inches creates a vacancy in the initial contract, as well as how do you measure this? Is it my height, your height, at the base, at the top? And there were some issues as well regarding Mr. Simpson's testimony on behalf of DNR Logging as well. But again, I don't believe there's any findings of fact that specifically states that the plaintiff cut down all these trees under 8 inches diameter. I believe there was also, as identified by the majority decision, that there was this potential conflict in the evidence that would also need a finding of fact to resolve that. Whether we've just spent most of the time.
Before we go any further, I want to be clear. So other than the cross-examination of the direct examination of Mr. Hall on pages 135 and 136, is that the only evidence that you believe the trial court could utilize to resolve or to say that there is a dispute with regard to what measurement was used by the plaintiff in this case?
Justice, I believe that there were before and after pictures, and I don't have all the full record with all of the photos in front of me, but during the case in chief, so to speak, when we had Mr. Stevenson and Mr. Hall testifying, I believe that they had gone through, this is a picture of what it looked like before, and this is a picture of what it looked like after. So certainly there was, extensive testimony from Cameron Hall and from Shane Stevenson showing what the work looked like, what it looked like when they got there. I think these are plaintiff's exhibits 1, 2, and 3, and potentially 4, and then plaintiff's exhibit 6 and 7 show, even 8 show drastically different pictures there. So I mean, I still think visually the court can look at what the property looked at before, take that in light of Cameron Hall's testimony, and then show that he certainly did perform the work. I mean, there's
let's be clear. How do you look at a picture and determine a tree's diameter?
I don't know that you can, Judge. Again, I think it was ultimately on the trial court to decide whose evidence to believe, whether it was plaintiff's saying.
Yeah, but a trial court could not base a finding of diameter based on a picture that doesn't indicate tree diameters, correct?
I think that would go both ways, though. They wouldn't also be able to make a finding that there was trees above 8 inches based on the picture alone either. So I mean,
let me concede that, but then say, okay, we have direct testimony from your client saying we measured it around the tree as opposed to across.
So there was.
Yeah.
Sorry.
So what is the evidence that your clients actually measured a tree across as opposed to around?
It would be the rebuttal testimony, Justice. It would be when he came back up after these visual representations and testified. At this point, after the extensive amount of time we had spent in trial going over the distinction between diameter and circumference, if he was indeed measuring by trees the circumference or the diameter, and that's where Cameron Hall testified it was the diameter. Whether or not that finding in fact existed again was ultimately a decision for the court to find here. There was other evidence specifically that could have been used, I guess, at least by the trial court in making their determination of whether or not the plaintiff complied with the terms of the contract. Mr. Cox has pointed out that D&L Lager had testified that there were several rows of trees left standing that he had to cut down greater than a particular size. When asked on cross-examination if he was out there measuring the trees, he testified, no, I don't measure the trees. So certainly there was a conflict there as well that the court could have recognized in making their determination. Ultimately, I believe the appropriate standard in this case would be for a remand to allow the trial court to make the additional findings of fact. There was some argument in Justice Dillon's dissent there regarding the reverse and remand versus vacate and remand, I guess, phrasing. In my review, it appears that there is a distinction between those two, not just a semantic argument, but as he notes in the Lazary v. Stanley Martin's Communities matter in footnote 2, vacate in an order is to eliminate but not necessarily replace with a contrary order, as opposed to reversing, which is suggesting that the trial court got it wrong, to enter a new order directed or reconsider the matter but may not reach the same result. There is the Gilbert v. Guilford County case, Judge, or justices, that would potentially allow this decision or allow Justice Dillon's decision to enter judgment in favor of the defendant. It says if the facts are not in dispute and only one inference can be drawn from them, then the court is not required to remand. However, I believe that case is distinguishable from here. In Gilbert v. Guilford County, the defendant in that case put on zero evidence. The only evidence before the court was the plaintiff's evidence in that matter, so they could only draw one inference. And here, I know it's not necessarily the easiest of tasks, and that may require additional hearings, but ultimately, it would be up for, there is multiple inferences that could be drawn. We can look at, was he measuring erroneously based on the earlier testimony, or was he measuring based on the diameter or circumference based on the later testimony? So I still believe that the appropriate response here would be that of the majority's decision to remand the case for additional findings of fact that can then be supported by the trial evidence.
I'm going to ask you this question, and I'm going to ask it to the appellant as well. Was there anybody who testified that they went to the site, cut a tree down, measured it, and measured the diameter of what was cut down to indicate that what was left fell into the 6-inch to 8-inch category? Did anybody testify to that regard?
Mr. Edwards had testified that there were about, I believe, 90 trees, give or take, that were over 8 inches in diameter that were outside the scope of the work. As far as I recall from the trial, there was no one that actually physically measured any of the trees. It was all approximations. I believe that D&L Logging had testified that he was measuring based on the height, that longer or taller trees would have a thicker diameter. But to answer your question directly, no, nobody was out there with a tape measure measuring these trees. It was all based on their experience and eyeballing the size of the trees. With that, if there are no further questions from the court, I would yield my time back to the court.
Thank you, counsel. And before we have rebuttal, if any, I would mention to counsel that if you do want the court to consider cases that you have not cited in your briefs, you will need to do a memorandum of additional authority and submit it in that fashion. That being said, is there any rebuttal?
Yes, Your Honor. Just two things. First of all, I think Justice Newby, you had asked about testimony as to where that diameter is measured. On 127 of the transcript, which was my direct examination of Mr. David Simpson, who was the logger with D&L, I asked him, when you measured trees to be cut, what's the measure you use? And this is an industry standard question. And he said, well, according to the transcript, he said diameter and breast height. Diameter and breast height, okay, what's the diameter you measure it across? I think that's probably a error in the transcript. It probably should say diameter at breast height. Just as an aside, the Brunswick County trial witness microphone was not operable. So the court reporter who prepared the transcript did a really good job, because the only mic he had was on the attorneys and the judge. And so but I think that one he missed. Your other point about, was there anyone that went to the site, cut down and measured the tree? There was not any testimony from anyone who cut down a tree and then took a tape measure and measured that diameter on that stump. Mr. David Simpson did testify, and actually there's a letter as exhibit. He also testified in person that he cut down all of these trees, and that out of 13, I think it was 13 loads that he hauled away from that 8.5 acres, everything but 1.5 loads was under 8 inches in diameter. He did not testify that he took a tape measure and did it. He just did it based on his knowledge and experience as a logger, and that's kind of their job. That's what they do. That's all that I have.
Thank you, counsel. Thank you, everyone. Madam Clerk.
Oh yes, oh yes, oh yes, the Supreme Court of North Carolina is in recess. God save the state and this honorable court. Thank you, counsel.
Thank you so
Thank you.
much.